of Criminal Appeals of Tennessee is now in session.
All right, thank you very much, Mr. Hivner. Good afternoon. This is the January docket, oral argument docket for the Tennessee Court of Criminal Appeals here in the middle section of Tennessee at Nashville. My name's Robert Wiedemeyer. I live here in Davidson County. My distinguished colleagues today are Judge Robert L. Holloway, Jr. From Columbia, Tennessee, and Judge Timothy L. Easter from Williamson County, Tennessee. We are pleased to be able to have these oral arguments via the technology available, and it's been made available by the Tennessee Administrative Office of the Courts and the technology people there, plus the excellent efforts by Clerk Hivner's office and his staff and our staff attorney. And we thank the attorneys here also for participating in this type of oral argument. We're grateful to be able to do this, but we would definitely rather be in the courthouse like we usually are. And hopefully the time will be here soon when we can return to in-person oral arguments. But for now, we use this technology to move these cases along and allow oral arguments on cases where the attorneys requested. So that being said, we have read your briefs. The rules are basically the same as if we were in court, 20 minutes allowed for each side to argue their case. If you represent the appellant and you wish to reserve some rebuttal time, please let me know before you begin your argument, and I'll help keep up with the time for argument. I think that's all of my opening comments I need to make. Any preliminary matters, Mr. Hivner?
No, Your Honor.
All right, if you'll call the next case, please.
State of Tennessee versus John Dennis Green.
All right, thank you. Is this Mr. Taylor?
Yes, sir, Your Honor. Good afternoon.
Good afternoon. We're ready when you are.
Thank you, Judge. Your Honors, good afternoon. Counsel, good afternoon. Thank you for having us in this format. My name is John Taylor of the Rutherford County Bar, and I'm here on behalf of the appellant, Mr. John Dennis Green. I would request 5 minutes of rebuttal time to be reserved, please.
All right, certainly.
And just by way of status, this case was tried to jury before Rutherford County jury by my late law partner, Mr. Dotson. Unfortunately, he passed away this summer, and I have taken the mantle of taking this case before Your Honors today. And I would say that both the state as well as the court has been very accommodating to me in the difficulty with their office, and I would like to express appreciation for that before I begin. That's important for me to have to make that clear. I have presented 2 arguments in my brief, one of which being the sufficiency of the evidence for the conviction, the other being the what we purport to be an error related to a self-defense jury instruction. For sake of time, I would submit my written brief argument as it relates to the sufficiency of the evidence, and for today's purpose, focus entirely on the jury instruction issue. So just by way of housekeeping, I will focus my comments to the self-defense jury instruction error in particular. As the court is well aware, this was a charged offense of domestic assault and aggravated assault against my client, the appellant, Mr. John Dennis Green. Essentially, the testimony involved competing accounts of a fight, an escalating argument that resulted in physical violence between 2 parties on the evening in question. Now, the issue that's been raised by the appellant in our brief is that the court failed to properly instruct the jury on the issue or the defense of self-defense. And as I have cited extensively through my brief, the law is very clear that the instruction of self-defense must be given if the issue of self-defense is fairly raised in the proof. And the law, longstanding law, is very clear that the burden upon a defendant to, quote, fairly raise self-defense in the proof is very slight, and it's considered to be less than the preponderance of the evidence. Case law goes on to say that the court is not to assess credibility or weight or assess the truthfulness of any claim of self-defense, but recognize that it has been fairly raised in the proof. A number of ways in which the court, this court, and the Supreme Court has deemed that issue to have been fairly or properly raised in the proof can be drawn from the defendant's theory of the case, the evidence as to injuries sustained by the defendant in an altercation such as the one at issue before the court today, and ultimately the issue of self-defense is a factual issue, one that is to be determined by the jury if they are properly instructed. And what has been cited in my brief as well is that a failure to give a self-defense instruction when it has been fairly raised in the proof is to be considered a reversible error. Now, as we examine the trial and whether this threshold question of whether it has been fairly raised in the proof was adequately met in the trial, I would draw the court's attention to a number of items. First of all, as it relates to the defendant's theory of the case, it was presented from the outset to the jury that this would be a self-defense case. It was indicated in opening by defense counsel, my late partner. It was commented on additionally by the state in its opening, and it was unequivocally presented as a theory of the case from the defense perspective. And in particular, what was probably the most disputed element of fact in the entire trial, including the proof, was not only the issue of who was the primary aggressor between these two parties, but also who was the initial aggressor. And there was competing testimony between the alleged victim and the defendant, the appellant, as to who did what and when, who was the primary aggressor and who was the initial aggressor. So just from the outset, the concept of self-defense was categorically before the court at the outset of the trial, beginning with opening statements. Now, if we examine the actual proof, which is really what the court has to go on, whether it was an appropriate instruction or lack thereof, let's look at the proof. Let's look at the testimony. Beginning with the alleged victim, on multiple occasions, in multiple items throughout her testimony, she specifically testified to striking, making physical contact, and or harming the defendant, the one who is claiming the defense of self-defense. She admitted to kicking the defendant, to scratching the defendant on the neck, to scratching the defendant on the nose. She admitted multiple other physical contacts on the defendant, and ultimately she made 5 specific admissions of striking or otherwise causing physical contact or physical harm to the defendant. If we examine the testimony of one of the investigating officers who testified in the trial, Officer Chang, he specifically noted visible injuries to the defendant's face, to the defendant's neck. He noted that it was EMS who actually treated the defendant for his injuries to his head and neck area. And he authenticated certain photos that are exhibits to the court file that demonstrated those reported injuries that were inflicted upon the defendant as a result of the contact initiated by the alleged victim. Now, beyond that, the appellant did testify, the defendant did testify in this trial, and he testified that it was the alleged victim who made the first physical contact with him, that he was struck multiple times by the alleged victim, that he was hit with multiple objects, either being struck from the hands of the alleged victim or being thrown by the alleged victim. He testified to trying to escape, and he testified that he did sustain injuries to his face, head, and arm area. Now, what I think is actually very important to this issue, the state raised an issue in its brief. I certainly don't want to get ahead of counsel on that, but suggesting that well, if he denied certain contact, then he wouldn't be entitled to a self-defense instruction. I would dispute that and how that was presented in the trial, because the defendant did not deny making contact with the alleged victim. He admitted to making contact with her. He specifically said he made multiple attempts to escape or multiple attempts to leave, which were initially thwarted by the alleged victim, and then he had to make physical contact with her as he escaped the fight or escaped the premises. And although he denied what was specifically alleged by the alleged victim, that he had specifically struck her and choked her, he did not deny making physical contact with her. So we have an instance where there is physical harm being inflicted upon him and the defendant admitting to making physical contact with the alleged victim. And I think that is an important point to note. Now, in the state's brief, the state essentially argues that if the defendant, quote, denies inflicting injury upon the alleged victim, then he's not entitled to a self-defense instruction. And I would point out again to the court that although the defendant made specific denials to choking and striking the alleged victim, he did not deny making physical contact with her, but he testified that his physical contact with the alleged victim was because of the act of self-defense and or escape in trying to escape the attack that had been initiated by her. Now, the state cites two Tennessee cases to support that theory. One is the 1926 case of State versus Green, and in that case, the only alleged conduct that was alleged against the defendant was shooting the victim. There was one point of contact, and it was a firearm shot into what became the alleged victim. And in that instance, the defendant himself said, I didn't shoot the person. So there was one alleged physical contact that was denied by the defendant, and therefore the court ruled you're not entitled to the self-defense instruction. Again, that is wholly distinguishable from this case because the defendant did not deny making contact with the alleged victim. It was just the manner of contact that he denied. The second case that is cited by the state is this 2000 case of Blackwood. And again, that involved a firearm specifically. And the allegation was that the defendant intentionally fired towards what became the alleged victim. And there was no allegation of any other contact. There was no allegation of any other harm. The manner of alleged harm to the alleged victim in that case was a specific shot by a firearm towards or against this alleged victim. And again, in that case, the defendant denied doing that very specific act, and that was the only act that was alleged. And ultimately, the court ruled that you're not entitled to the self-defense instruction in that instance. This case is wholly distinguishable from that because although the defendant or the appellant denied striking and choking specifically, there were multiple other alleged points of contact that were litigated in this trial. And ultimately, although the defendant did admit to making some contact with the defendant, it wasn't all, or with the alleged victim, it wasn't all of the alleged acts that were accused or that were alleged by the alleged victim in the state. So I see that as completely distinguishable. It's not a matter of the only contact that was alleged was then denied, and ultimately self-defense instruction was not permissible at that time. In this instance, there was a dispute as to the manner and extent of contact, and both parties admitted to making physical contact with the other person. And therein lies the issue of fairly raising the issue before the jury in its proof, in the defendant's proof. And that is our position, is that, you know, there were multiple instances of proof or testimony that the alleged victim was engaged in conduct that threatened the person of the defendant, and that he engaged in other physical acts in order to defend himself and or escape. And it is our position that therein lies the error in not allowing the jury to have heard the self-defense instruction. So with that, I'll yield back my time and
I have one question, Mr. Taylor. The
Yes,
way I read the brief, after all the proof, there was a charge conference. Is that correct?
yes, sir.
And the defendant asked for a charge of self-defense, and the state objected.
That's correct.
Then there was some type of hearing, I guess, or argument, and the state withdrew its objection to that charge. Is that correct?
That's my understanding. I believe the way that it played out was that the defense requested the instruction. The state lodged its objection. I believe Judge Taylor at the time said that because they were at the end of the day, I believe, so that he was going to examine the law, return to court, and make a ruling on the instruction, whether that would be permitted or not. And ultimately, I believe it did play out the way that Your Honor had recounted.
So the state announced that it withdrew its objection.
I believe that's correct. Yes, sir.
Mr. Taylor, I've got a real short question for you, and it's probably in your brief, but you've got to try. It's about standard of review. Yep. Your trial judge says self-defense is not fairly raised by the proof in this case. So our court's looking at it now. Is it de novo or abuse of discretion, or which of those would it be for us to try to figure it out?
That it is de novo without a presumption of correctness, Your Honor.
Okay. All right. Thank you. You want to reserve your time for rebuttal then, and we'll let the state argue. General Finley, good to see you again.
Good afternoon, Your Honors. May it please the court. David Finley on behalf of the state. So as the court has noted, the state did not oppose this charge. The trial court took a recess, did some research, came back, and said because there was no proof that the victim's injuries were inflicted by the defendant, that there was no reason to charge self-defense. We've cited the court to Tennessee cases that pretty much hold the same, and some domestic abuse cases in other states that also hold the same. So there is some support in the law for the trial court's holding in this case. And I think it's important to note that, as we cited in our brief in State v. Sims, the question is whether there's evidence that reasonable minds could accept as to the defense. And in this case, there simply isn't. The defendant's the only contact the defendant admitted to in his testimony was he had to push by the victim to get to the back door. So there's nothing. None of his testimony establishes that he used his hands. He just basically, as I read the record, he had to kind of shoulder by her, kind of push by her to get out the back door. As I think I've made clear in my brief, he vehemently denied striking her or inflicting any of the injuries on her at all. So we submit that the trial court properly denied the self-defense charge. Even if this court disagrees, however, we submit that any error was harmless beyond a reasonable doubt for the same reason. The defendant would have to have argued diametrically opposed positions in his closing argument. He would have to argue, number one, if you believe me, then we don't know how she got her injuries. Number two, if you don't believe me, then I did it in self-defense. So under Sims, there was simply no proof that reasonable minds could set as to that defense. And two, even if this court disagrees, that any error was harmless beyond a reasonable doubt, given her nature of her injuries, which, as I pointed out, include a bite mark on her cheek. I think the reading between the lines of the defendant's testimony, I think he's inferring that she inflicted most of these injuries on herself. I don't see how she can inflict a bite mark on her own cheek. So we would submit that even if the court disagrees with the trial court's ruling in this case, any error was harmless beyond a reasonable doubt.
All right. Thank you, General. Mr. Taylor, you've got your 5 minutes if you want to argue again?
I think that my brief and my initial comments are sufficient for today's purposes. Thank you. Thank you, Judge.
All right. Thank you, Mr. Taylor and General Finley. We appreciate the arguments and the briefs, and we'll take the case under advisement. And we're going to be in recess, Mr. Hivner. Actually, I think we've concluded the January docket, so we'll be in recess till the February docket. I can't hear you.
Sorry, Your Honor. Thank you.
All the way to the very end.
Hey,
This honorable court is now adjourned.